First of all, let me welcome all of the attendees and panelists to our session today, our Tech Web Policy webinar organized by the San Francisco Bay Area Internet Society chapter. And also welcome to everyone on International Women's Day today. And thank you all for joining. My name is Robin Gross, and I am an attorney in San Francisco at imaginelaw.com. And I am also on the board of directors and the policy chair for the San Francisco Bay Area chapter of the Internet Society. All right. First, let me do a quick review of how our session is going to run today. We will each have some introductory remarks from each one of the panelists, and then we will have some moderated panel discussion amongst the panelists with specific questions. And then we've got some time for the attendees to ask questions for our panel members as well. So in order to get your question in, we ask folks to use the chat box and type the word question into the chat box, followed by the question that you'd like to ask. And you feel free to do this at any time during the course of our session, because we will be keeping track of those questions and collating them over and bringing them back into this part of the session here, the Q&A session. And then we will have a few final remarks from each one of our panelists. And then we'll tell you about what we're going to do next month. Okay. Where did my screen go? Okay. So what precisely is the 26 word that created the internet? Well, here it is. No provider or user of any interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now, this is a federal law, and it was passed in 1996 as part of the Communications Decency Act. And this was an act that was really aimed at curtailing the proliferation of internet porn. And Section 230 was just sort of tucked in there as a side thought. And the most of the parts of the CDA that dealt with internet porn got struck down by the Supreme Court. But what remains is Section 230 and the liability shielding protections that it provides to users and providers of interactive computer services. Now, it's really no exaggeration to say that Silicon Valley was built on Section 230. We've got entirely new business models that deal with third-party content, and it's really just proliferated, and it's really become a multi-billion-dollar industry. And in large part, it's because of these kinds of liability protections that are found in Section 230. Well, there's also arguably an ugly side to this as well. Disinformation and hate speech have been allowed to flourish in places, and it threatens democracy and can oftentimes facilitate violence. So we need to think carefully about this as well. And last year, Congress introduced over 20 separate bills to amend Section 230. And last year, President Trump had a war on Section 230. Following Twitter's decision to put fact-checking labels on Trump's tweets, he issued an executive order in May asking the FCC to consider narrowing those protections. And then in December, Trump vetoed the defense bill because Congress did not meet his demands to eliminate Section 230. And right now, we've got more than 24 looming federal bills to amend 230, and they've got bipartisan support. This isn't just Republicans or Democrats on opposite sides sort of issue. Silicon Valley Congresswoman Annie Eshoo, she issued a proposal that would hold tech companies liable for the algorithmic promotion of extremism. And last month, a number of Democratic senators introduced a proposal that would curtail the immunity for paid content and allow wrongful death litigation to go forward. So many legal and policy experts agree that some type of reform to the law will take place during the Biden administration. And some worry that the golden age of internet innovation will end if the law is substantially altered. So here to take up this conversation, we have a panel of distinguished legal experts, and it is my pleasure to introduce them. All right. Our first panelist today will be Professor Eric Goldman. He is the Associate Dean for Research and Professor at Santa Clara University School of Law. He is the co-director of the High Tech Law Institute, and he's the supervisor of the Privacy Law Certificate. He writes for the Technology and Marketing Law blog. And it is on no exaggeration to say that he is really one of the nation's most prolific writers and commentators on Section 230 legal cases and efforts to reform or to repeal it. Okay, and then our next speaker will be Elizabeth Banker. She is the Deputy General Counsel at the Internet Association, where she focuses on data privacy and security and intermediary liability issues. The Internet Association represents leading global internet companies on matters of public policy. And the association's mission is to foster innovation, promote economic growth, and empower people through the free and open internet. Previously, Elizabeth advised Yahoo and Twitter on law and policy matters. And through the Internet Association, she has published a report last July, which analyzed over 500 Section 230 legal cases that have been brought over the last 20 years. It issues a number of important key findings and insights that can help us to think about 230 going forward. Our next panelist will be Andrew Bridges. Andrew is a partner in the law firm Fenwick and West, and works out of the San Francisco and New York offices. Additionally, he is the co-chair of the copyright litigation at the firm. And Andrew has more than 30 years of experience litigating cutting-edge technology cases. And in addition to that, he's a longtime member of our chapter, the San Francisco Bay Area Internet Society. And our fourth panelist is Mike Godwin. Last year, in 2019, Mike was elected to the Board of Trustees of the Internet Society. In 1990, he was the first staff attorney at the Electronic Frontier Foundation. And in 1990, he created the Internet adage of Godwin's Law. Mike has spent many years as the general counsel for the Wikimedia Foundation. He's been the director of, the legal director at Public Knowledge, the director of innovation policy, and the general counsel for the R Institute. And last August, Mike filed a lawsuit against Trump on behalf of TikTok employees after Trump tried to ban the video app company. So as you can see, we are extremely fortunate to have these four extremely knowledgeable internet pioneers, each from a different perspective. There's the academic perspective, industry perspective, litigator perspective, and civil society perspective. So without further ado, let me turn it over to Eric Goldman for his introductory remarks. Thank you.
Thank you, Robin, and thanks to the organizers for putting this event together and for assembling this fine group of panelists. It's a great honor to be a part of this group's activities and to share the stage with the panelists. And it's really terrific to have a chance to talk about Section 230. It's been the subject of so much discussion and much of it misdirected. So I'm really thrilled that we'll have the chance I hope to make sure everyone understands what's at stake here, what we're fighting for, and the risks that we're facing to our internet today. Robin laid out the 26 words of Section 230, and I'm not going to repeat them here, but I'll translate them into English, because if you looked at the wording, you probably were a little confused. But simply put, Section 230 says that websites aren't liable for third-party content. It creates a categorization between first-party content, which the originator of that content is liable for, and third-party content, which online republishers of that content aren't liable for. And there's been some public surveys done about Section 230. And if you ask people, are you for or against Section 230? Nowadays, a small majority of people will say they're against Section 230. Certainly the events of December that Robin mentioned, where Trump was just pouring gasoline on Section 230's fire, didn't help with his public reputation. However, if you ask people, should online publishers be liable for third-party content, an overwhelming majority of consumers will say, of course not. That doesn't make any sense. Hold the people accountable for the words that they publish, but then don't hold the other people in the chain liable for that content. And the basic gist behind that, or the basic concept behind that, is that if we do that, we're allocating responsibility to the people who should bear that responsibility and freeing up the others to make a wider range of choices that we want them to make. And in particular, Section 230 was enacted in the face of two early 1990s decisions that created what I've called the moderator's dilemma. The idea is that under the pre-1996 rules, if a service tried to moderate content and missed anything, if it didn't do moderation perfectly, it was liable for whatever it missed. Whereas in that circumstance, then many services started to say, maybe we don't want to do content moderation. Maybe we don't want to try to police the internet for content, in which case the bad guys win. The trolls, the spammers, the antisocial contributors, they overrun any service that doesn't exercise content moderation. So Section 230 solves that basic moderator's dilemma by allocating responsibility to the people who should bear it and by freeing up the others who shouldn't. As Robin mentioned, this has been the foundation of our modern internet. If you look at the list of the top 10 most used services, there's a lot of different ways of measuring it. It doesn't really matter. Almost all of the top services that you'll see on that list rely extensively on Section 230 for their basic premise, for their basic value propositions they offer to consumers. And so when you look at the things that we do on a day-to-day basis, or even an hour-to-hour or minute-by-minute basis, Section 230 plays a role in enabling us to interact with each other and to communicate with each other online at that level. So it's something we're benefiting from constantly. This Zoom call or conversation is benefiting from Section 230. Zoom isn't sitting there worrying about what liability might have from all the stupid things I'm about to say. And so the fact that we're getting these benefits on an everyday basis is what built the internet. It's what I think makes the internet great. Section 230 sits on top of the First Amendment. It isn't a replacement for the First Amendment. It's a supplement or complement. It's what I call a speech enhancing statute. It takes the principles of the First Amendment, which sets a floor or baseline of free speech in our society, and says, we're going to do more free speech in our society. We're going to do more than the First Amendment requires. And one of the ways that Section 230 does it takes the basic free speech principles of the First Amendment, and it provides what I'll call a procedural fast lane to resolve matters in court. When a service that's not liable because of Section 230 gets sued, they in theory could invoke the First Amendment and get embroiled in constitutional litigation, which Andrew might think is fantastic, but the client probably doesn't. Or it can invoke Section 230 and it can say, I'm not liable for this, I win. If the court grants that on a motion to dismiss, the case ends both with confidence and quickly and relatively at low cost. And it's that ability to fast track these cases that otherwise would be constitutional litigation that helps Section 230 provide the economic safety net that internet services need in order to be able to stand behind their users' content and to not fear that they are going to be liable for whatever mistakes they made. All of this is in play today with the moves that Congress are making. We're going to talk about that through the session, but the stakes at issue here are really fundamental to the basic central premise of the internet. What does the internet do? What does it mean to us on a day-to-day basis? Those are all things that your members of Congress right now are putting in play and jeopardizing.
Thank you so much, Professor Goldman. Now let's go to Elizabeth Banker.
Thanks, Robin, and thanks very much for inviting me to participate. today. I'm always happy to have a reason to talk about Section 230. And I appreciate the remarks that Eric gave, and I think laid a great foundation for the conversation. So I won't try and replicate any of that. I think, maybe just to carry on from the foundation he laid, I think one of the things that gets really lost when we talk about Section 230 are the benefits for consumers. And, I think about the services that people use on a daily basis that I, as somebody who's worked in this field and do it because I love the various online services that are out there. As he was saying, every service pretty much that you interact with on a daily basis is there because of Section 230. And so in the title of this discussion, there's the word free expression. The internet has given people far more opportunity to be expressive and to consume the expression of others than really at any time in history. And I think sometimes when we hear people talking about bias and people being shut down and not being able to express themselves, it really fails to recognize that, it's not just, a small handful of really big social media companies out there that people have as options. There are so many different ways that we can all express ourselves. The association I work for, we've got, 45 plus members, and many of them are offering those products and services. So that was one point I wanted to make. The other point is in terms of consumer benefit, consumers get a lot of benefit from Section 230's protections for how providers actually moderate their services. As Eric said, services could be overrun with spam and, malware, phishing attempts, harassment, like the list goes on. But Section 230 is there, and it really protects those decisions and the actions that providers take, which is really critically important, particularly as we move to more and more content moderation being done through technology. It's, it's got risks with it. And I think we all know that there is a risk that it will, those algorithms will identify something that maybe isn't violating or miss something that is. But what Section 230 does is it gives the protection for providers to be able to try those things and continually fine tune them. In the discussions about Section 230 and whether it should change, and if so, how it should change, I think that the conversation is not in a good place. 230 has been picked up, for a lot of different types of concerns that people have. And there's a really important question that we have to ask when someone does have a proposal to repeal or change Section 230. And ultimately, that is, what is the problem they are trying to solve? And will changing Section 230 or straight out repealing it actually do what they're hoping it will? So one example, right now, in response to the actions taken by large social media companies against President Trump's account, in the states right now, there are more than 27 states with more than 50 bills that I would characterize as anti-censorship bills. So what these bills are trying to do are they are trying to restrain companies in their ability to remove or restrict or limit in any way content that violates their terms. These bills are really problematic. The first one just passed in Utah last Friday. We expect it probably will be signed, but these bills are really misguided. And they get to 2 points. One is there's a real risk that they're going to dramatically interfere with the types of safety protections that I think most of us have really come to take for granted in terms of the services we use every day. I remember email before there was a spam filter. I don't want to go back to that. So, there are real harms that could come to consumers from providers having their hands tied in terms of being able to remove content. But also, because of the First Amendment, these bills are not likely to have any real impact. As Eric said, litigation's expensive, and without Section 230, litigation becomes more expensive. But in terms of the results, we really don't think that they'll change. So what is the benefit of opening up all this potential litigation? It's not really clear. And in fact, what's even stranger about all of this phenomenon is it's not actually clear that any of the states that are enacting these bills actually want them to do anything. Some of them actually have bizarre carve-outs for if there's immunity under federal law, none of this applies. So I think that's a trend to watch. And as we go through the program, I think we'll see one of the other dangers as we talk about recent proposals at the federal level, which is that they're going to have the opposite effect from what's intended. Because oftentimes when measures intend to encourage providers to actually moderate content more aggressively by exposing them to criminal law and to private civil actions for federal criminal violations, what they're really doing is saying and returning us to exactly the situation that Section 230 was designed to prevent, which is a disincentive for providers to take the actions to look for violating content and remove it because of the risk that they could miss something and be sued and held liable. So I will leave it there, and I look forward to discussing these issues with the rest of the panel.
Great, thank you so much, Elizabeth. Our next speaker will be Andrew Bridges.
Thank you very much. I'd like to start with a question that Elizabeth posed a minute ago, and I'd like to expand upon it a little bit more. First is, what are the problems that reformers are aiming to solve here? And are they problems that any reform of Section 230 can affect? What I find remarkable is that you find opposing political parties and opposing political viewpoints having very opposing viewpoints about what is wrong with the internet and how to fix it. This has led to some performative opportunities for them to try to agree on something that really isn't at the core of either of their interests. And that we saw with the enactment of FOSTA Sexta on the theory that everybody can get against sex trafficking, and people can say, well, I've done something about it as a political performance. What is going on, however, is that traditional media, I think, are part of this. And what is the problem that they are trying to solve? The problem that they were trying to solve is the power of new internet companies that sort of challenges the oligopoly that traditional media have had. And moreover, I think the problem for them is the relative lack of gatekeeping of public speech. The traditional media have typically had very tight control over what got into people's fields of vision, what got before people's eyes and in their ears. And the number of sources, the competition for traditional media has exploded with the development of the internet. So what's going on? What we see is there are some real harms and real wrongdoing on the internet. But with the focus on Section 230 and the focus on the large social media companies and internet companies, we see a massive deflection from where responsibility should lie. Massive deflection from the sources of the problem to the messengers that may reflect or amplify bad events, bad statements that have already gotten onto the internet. But there are some companies that have mediating roles facilitating the public getting wider access to them. And so instead of attacking the sources of the problems, there is this fantasy that by attacking intermediaries, those underlying problems will go away. So a lot of it is internet bashing. So I have a question. Do we have enough internet? Do we not need any more internet? Do we have all the internet companies and social media companies that we need? Do we not need any more? There's a lot of attention about Google, Facebook, Twitter, and the like. There are many other platforms out there with a variety of different approaches with different interests and different timelines. We have a lot of other types of approach arising on the internet. So it's not just the big ones. There's Pinterest, which is older, Reddit, which is older, TikTok, which is newer, Parler, don't get me started, Discord. There are a lot of other companies. This is not just some small oligopoly that established itself a while back and is going to have permanent control. No, there's a lot of new approaches coming up. And the question is, do we not want new approaches? Because one thing that is clear, when there is more regulation, particularly onerous regulation, that will privilege the incumbents against the innovators. So the question is, have we had enough innovation? One thing I want to talk about is that users are the place to create the pressure points. There's a lot of talk about suing Twitter or suing Facebook for alleged wrongdoing. There's less attention about, well, do we sue the actual originating speaker? Do we sue people who have actually put something out on the internet and caused harm, as opposed to the media that happened to channel it? Let's also think about the responsibility of traditional media for so much of what's gone on. Look at the incumbent media and the professional media sources that have been sources of disinformation. And I'm talking about Fox News, Breitbart, the Trump White House press room has been one of the greatest originators of fake news and disinformation in society. Why not blame the people standing at the podium instead of people who may, the companies that may carry the retweets of fake news? So there needs to be a focus on those sources. By the way, the original social media, I think in my book, talk radio and Rush Limbaugh. Let's talk about those social media and the role they have had in disinformation and the like. One last thing I want to point out is that Section 230 of the Communications Act, what we're calling the Communications Decency Act, is not just for internet companies. If I may share my screen very briefly, I would like to point one thing out in the statute. Can y'all see it? Okay, so let me go down right here. These are findings, policy, and this is the core of the law. The 26 words that Eric referred to are in section C1 here. What is the fourth word of that section? User. No provider or user of an interactive computer service shall be treated as the publisher. What does that mean? It means users are protected by Section 230 for forwarding an email that might have a problem with it, for retweeting, for sharing something. This is not just about consumer benefits because of the effects on internet companies. This is also about citizen consumer protection. And this is getting lost in a lot of the discussion that's at the sort of internet company level. Thank you.
Thank you very much, Andrew. And our fourth speaker will be Mike Godwin.
Hi, everybody. I'm going to try to, let me set my alarm here so I make sure to stop before I talk too much. But I wanted to, I've been thinking about what I could add to what other people are saying today, and I decided to try to add something maybe a little bit different. Eric started out by pointing out that Section 230 adds to the First Amendment, or it's speech enhancing. I think that's true, but I wanted to really emphasize that in another sense, it's nothing special. Let me just say that again. Section 230 is nothing special. And the reason I'm saying it just that way is that a lot of people think that Section 230 is the special law that's been created for big tech companies to take advantage in a certain way, and it's exceptional. And if the real law, if the larger law were imposed upon tech companies, everything would be better. But that's actually a misconception, and let me explain why. Eric alluded to the fact that there were these two cases in the early 1990s in which tech companies, people who are providing what we would now call social media platforms were being sued for defamation. In 1991, it was a case against CompuServe, Cubby versus CompuServe. And the interesting thing about that case, this is right when I was beginning my career as a lawyer. I was in my early 30s. The interesting thing about Cubby versus CompuServe is that reached back into the heart of American First Amendment law to reach its result. What it did is it said, our tendency is to say that all of communications law is either about editing a big newspaper like the New York Times or running a telephone service. And if we edit a big newspaper, we're liable for everything we carry. And if we run a telephone service, we're not liable for anything we carry. And those are the only two choices. But in fact, there was a third choice. And Cubby versus CompuServe reached all the way back to 1959 when I was 3 years old. They reached back to Smith versus California and they said, oh yeah, we also don't want to make bookstores responsible for the books that they carry for the content, because no bookstore owner normally reads every book that he carries or that she carries. And the principle here that the Supreme Court, US Supreme Court invoked, was a principle called scienter. Now, just forget that word. You're never going to hear it again today or anywhere else in the next week. But it means guilty knowledge. You knew or should have known what the content of the book was. And bookstore owners don't read all their books. Everybody knows that. But here's the thing. If you were a bookstore owner and you had to be responsible for every book that you carried, and if you were a newsstand owner and you had to read every magazine that came in every day, you would never be able to run a bookstore or magazine because you couldn't know about human could read all that stuff, or they'd be very tiny operations. That's the other alternative, I guess. But in any case, the Supreme Court said we're not going to hold bookstores liable for the content of the books that they carry, absent proof that you knew or should have known what the content was. Now, bookstores make choices, newsstands make choices. They decide to curate content. They decide to send books back if people aren't buying them, if they think they're the wrong books for the audience. They get to make choices. And that's a First Amendment privilege that the Supreme Court recognized back when I was 3 years old. So later in my early 30s, when Cubby versus CompuServe happened, I thought, hooray, they've solved this internet defamation liability question for all time in 1991, and I'm never going to have to think about it again. Wrong. Because in Cubby versus CompuServe, the federal court said this Smith versus California principle applies. CompuServe is more like a bookstore than it is like a traditional publisher or like a telephone service. Hooray. But a subsequent case got the case absolutely wrong. Stratton Oakmont, a different judge, said, oh, you know how that earlier case said there are 3 kinds of First Amendment entities? Well, no, there are only 2. Did you edit? If you edited, you're responsible. So in fact, it just said the opposite of what Cubby said and the opposite of what Smith versus California said. And the fix for that, Congress said, was to pass Section 230. Section 230 was passed by Representatives Cox and Wyden to take this principle of guilty knowledge as the principle for liability and put it in the statute. Now, how did they do that? They did it by saying, if you are a service provider and you're carrying content and you created the content yourself or you helped develop it, in those cases, you are, under the language of the statute as we wrote it in 1995, 96, you are legally liable. But if you aren't the creator or the developer of that content, you're not, because if you're not, then you don't have scienter. Oops, I said that word again. I meant guilty knowledge, but you don't have that problem. So Section 230 actually took the core of American First Amendment law. And why do I think that Smith versus California is the core? This 1959 case is the core of American First Amendment law. The answer is another case that happened 5 years later, Times Inc. versus Sullivan. In that case, the New York Times was sued by a Southern politician for carrying an allegedly defamatory ad that criticized the politician's actions on segregation. And the Supreme Court held in Times versus Sullivan in a principle that really freed up American press to do really important First Amendment work, that if you do not have actual malice, they called it, if you did not publish something that you know is false, or that you are reckless about whether it's true or not, if you are merely negligent, but you're publishing something about a public official or later a public figure, you are not, if you don't have actual malice, then you're not going to be held liable. That principle, lack of actual malice, lack of scienter, that's the third time I've said it, the lack of guilty knowledge, those are things that were built right into Section 230. So whenever you read a newspaper editorial, or whenever you read a journalist in a traditional journal who says Section 230 needs to be reformed, ask them if they want to repeal Times versus Sullivan. Ask them if they want to repeal Smith versus California, because what they're really trying to do is take the same guts out of the core First Amendment law and take it out of protecting you and me and the service providers on the internet. And I'll stop there. I think I've given you enough to think about.
Thank you very much, Mike. Now I've got some my questions for the panelists, and I'd like to also remind the attendees to please type their questions that they might have into the chat box, and we'll be collecting those and bringing those back in a few minutes for the panelists to answer. Okay, so the first thing that I thought we could talk about is, most of the world does not have the online speech protections that are afforded by Section 230. That's an American concept. It's a US law, and there aren't many other places that have that sort of protections. Well, last month, there was a Malaysian court that ruled that online Malaysian news site was legally responsible for the reader comments that were deemed insulting to the judiciary. The Malaysian court ruled that the online news site was required to vet comments and refrain from posting those comments that constituted contempt of court. The news site was fined $124,000 over 5 reader comments that were critical of Malaysia's judiciary. So this is the kind of thing that happens in the world outside of Section 230. So how would the internet evolve without these 230 protections? What does it mean for small businesses in particular if we do away with these protections? What does it mean for speech in regimes that have high censorship? Any panelists want to take a stab at this?
I can start. Robin, I think part of the answer comes from just what we've seen happen. So in Europe, there have been sort of similar decisions. And what we have seen as a result of that is a lot of newspapers closing comment sections. So I think that's kind of what we will see if Section 230 goes away. One of the things I know, IA did a survey a while back just to get a sense of what people value most in terms of online services they use. And, one of the things that we know is that consumers really value reviews from other consumers. I think, as a lawyer, when I think about reviews, that makes me really nervous. Reviews without Section 230 means that every negative review is potentially a lawsuit. A meritorious one or not, that is still a real problem. And so, providers without 230 would find themselves in a position where they would have to, either make very calculated and well-informed decisions, or just take things down when they get complaints, or, maybe they decide that reviews aren't core to their business, that it's just an added benefit that they provide to give users a little more confidence buying from a merchant they've never heard of, or trying some new product that doesn't have a lot of a track record out there. So, that's where I would start it. I mean, it would require providers to make really hard choices, and undoubtedly some of those are going to result in certain things that users love going away.
I just follow that on a bit. Hard choices, but also when we're talking about a lot of the types of claims of wrongful material, these companies are simply not competent to make some decisions. If somebody posts in a community chat that Bob is having an affair with Sally, and Bob or Sally threatens a lawsuit, is that something that the platform needed to spend a month sending private investigators around snooping to figure out whether this rumor that somebody posted was accurate or not? Now, somebody could say, okay, something like that's not societally important, we don't need it there. But what if it's this politician is having an affair with that politician, where it's very much relevant? It's putting platforms in an impossible situation to be guarantors of the character of the speech that they allow other people to provide. I'd also like to add one thing to Mike's reference to Smith versus California. Earl Warren, before he became Chief Justice of the United States, was Attorney General of California. And at one point, I understand he actually tried to prosecute a telephone company employee because the employee would not cut telephone service to somebody who is alleged to be using telephones, as many did, to run a gambling operation. I mean, there are many different analogies that we can find where this is just the wrong pressure point. It's the wrong enforcement point.
Robin, if I can go back to your question about the comparative laws between the United States and other countries and what effect that has on the internet, I'd just like to point out that most of the innovation that we see in the user-generated content space comes from the United States, because of the fact that we have laws that that foster entrepreneurship and innovation, like Section 230, that don't exist in those other countries. You know, something like the Malaysia execution you mentioned absolutely chills the entire sector. Nobody wants to be the next defendant in those kinds of cases. But here in the United States, because of our different legal regime, we see all kinds of experimentation, innovation, new developments that simply aren't taking place in other parts of the world. And because of that, the United States has a global competitive advantage for the entire internet industry. We see new jobs created here in the United States that aren't created elsewhere. We see new wealth pouring into the United States from other parts of the world because of the fact that we have such an active, strong, user-generated content entrepreneurial community. So these are some of the ways in which the law touches us in ways we don't even really appreciate. It becomes a temple or an anchor for our entire economy because of the global competitive differentiation, the fact that other countries have adopted more restrictive laws that have suppressed entrepreneurship.
So let me just jump in and add a little bit more. I think that, you know, I try to follow legislation, internet-related laws and regulation in the EU and elsewhere around the world. I think that initially I was, and I still am, somewhat concerned about it because, as is the case even in the United States, there's a tendency for regulators and legislators to say, well, which of the models that we normally regulate are we going to fit you in? Are we going to make you more like traditional media or more like telecom, more like a telephone service? And the answer, I think, once again, is that we have to recognize, number one, that those aren't the only two models for how you regulate a mass medium, and that's where you go back to what we've done with bookstores and newsstands in the United States. But I think the other thing that's really important, and I see policymakers thinking harder about this in the EU and in some other places around the world, is the recognition that we have a lot of problems that are going to face the entire world in the 21st century, and we're going to need the brain power of pretty much everybody who could be online some of the time to help us solve some of those problems. And so what we really need to do is make sure that whatever the global norms are for citizen participation in the online world, we ought not to discourage people from being free to contribute to the massive problem solving on things like global warming, the need for different populations to migrate because of weather disruptions, things like that, solving particular kinds of climate and problems in growing food and providing resources into a growing world population. We need everybody's brain power online for that. And the thing you need to do to make that happen is make sure whatever the global norms are, that they accommodate systems that allow people and encourage individual citizens to be able to contribute online. So that's sort of my appeal generally to the global norms. And I think one of the things that you find if you deal in more international circles is that there's an increasing recognition in the among international policymakers that in fact we do not want the service providers to have too many incentives to shut people down. We want them maybe to shut down certain classes of speech. We maybe want them to regulate copyright infringement or enforce certain kinds, or be responsive to copyright complaints and to different kinds of child pornography or other kinds of illegal material complaints. But we don't necessarily want them to really be suppressing and filtering the speech from ordinary citizens all the time. And that's a growing recognition. And I think one of the things that we've seen in the world is that because of what Eric cited as the competitive advantage that the United States tech companies have had under Section 230, there was an initial reaction in the international community to think, well, the American companies are scofflaws. They're not really adhering to international norms. But now that they have their own companies that they want to have compete with Facebook, now that you have TikTok and other companies that are really, globally interesting, there's sort of an increasing recognition that maybe they don't want everybody to police all the users all the time.
Great. Thank you all very much for that. I'd like to pivot a little bit and talk about the relationship between the First Amendment and Section 230. And, excuse me, I want to present that, share my screen with y'all. Okay, so in order to tee up the discussion on the relationship between the First Amendment and Section 230, I'd like to just briefly read an excerpt from a poem written by Jess Myers, who is a Santa Clara law student and a legal policy specialist at Google. And it is the following. If you're upset that Twitter and Facebook keep removing content that favors your political viewpoints, your problem is with the First Amendment, not Section 230. If you're upset that your favorite social media site won't take down content that offends you, your problem is with the First Amendment, not Section 230. If you're mad at search engines for indexing websites you don't agree with, your problem is with the First Amendment, not Section 230. If you're mad at a website for removing posts, even when it seems unreasonable, your problem is with the First Amendment, not Section 230. If you wish websites had to carry and remove only specific pre-approved types of content, your problem is with the First Amendment, not Section 230. If you wish social media services had to be politically neutral, your problem is with the First Amendment, not Section 230. If you hate fact checks, your problem is with the First Amendment, not Section 230. If you love fact checks and wish Facebook had to do more of them, your problem is with the First Amendment, not Section 230. And at the end of the day, if you hate editorial discretion and free speech, you probably just hate the First Amendment, not Section 230. Okay, so that sort of tees up this bit of the discussion for us. Who wants to jump in and explain the relationship between the First Amendment and Section 230? What is the point of this poem?
Well, I don't want to, I feel like I already talked a lot about that, but I will just point out, just for the sake of reminding people in the Internet Society audience that ISOC is a global organization, and sometimes in other spheres we talk about Article 19. So let me just point out that Article 19 talks about the individual human right, not the individual human right, not a tech company right, but an individual human right. Andrew alluded to this as well. The individual right to seek and to impart information. And if you look at the First Amendment, what you see is the way the framers put it is it talks about the freedom of speech and of the press. And for a long time in our culture, we thought the press was one thing and speech was another thing. And I think now we're recognizing that new media have given speech the scope that the press used to have exclusively. So if you have problems with the First Amendment, the problem is that you now have the power of running at least a small town newspaper off your Facebook page. And we think, I think the presumption ought to be that you want to protect that. We could have a choice. It's like choosing where to live. And some people think you should only have the choice between living in an army barracks or a sewer. Army barracks are highly regulated, very clean, very safe, but you're not necessarily comfortable or free there. Sewers have their own drawbacks, but we think most people want to live in some space between those two, between super regulated and no regulation at all. And that's what the First Amendment allows, not just Section 230.
I'd like to add that this really hammers the point that Elizabeth raised and that Andrew amplified about what problem would Section 230 reforms. And if we think about Section 230 as sitting on top of the First Amendment, if we carve back Section 230, but the First Amendment still reaches the same substantive outcome, then the Section 230 reform didn't really do anything except take away that procedural fast lane and make it more expensive to adjudicate any disputes over the matter. And so what I like so much about Jess's poem is statement is that it reinforced that that unless you're clear about the problem, you may not fix it through Section 230 reform. You may not be able to fix it without changing the First Amendment and going through a constitutional amendment. And so if that's the case, we're going to have to build different coping mechanisms in our society. But we've already made the choice that that type of speech is acceptable or that type of publication decision is acceptable. That becomes the baseline, and Section 230 reform won't change it.
So maybe I'll talk about one other aspect of the First Amendment that I think is really important when we talk about Section 230 reform. I think sometimes people have the question of why there aren't more legislative proposals that go directly at the problems that people talk about, whether it's extremist content, domestic terrorism, or other, maybe even hate speech. I think one of the things we also need to really keep in mind as we talk about the types of content that are problematic and are certainly things that online companies care about taking down and identifying, that the First Amendment also really limits what the government can do in terms of mandating providers to actually screen and remove content. I think the good reminder is in the Communications Decency Act itself, where Section 230 is the remaining piece. Well, the other pieces have been struck down by the Supreme Court. So, just to kind of add another angle in terms of how the First Amendment works on Section 230 reform, I thought I'd bring that up.
I'd love to add one thing to what Mike said. Mike is absolutely right about talking about the role of the First Amendment protection for freedom of the press as implicated in modern day personal conduct. I think one of the things we really need to focus on is how freedom of association is actually the most fundamental right of all the First Amendment rights. Because, freedom of speech is useless for somebody in solitary confinement. You speak to the walls. It's the ability to connect with somebody else and to share. And there is an extraordinary importance, both psychologically and politically, in sharing. That it's like freedom of assembly at Tahrir Square. I mean, people are assembling online, and when we are getting upset about influences of some people on other people, we have to understand that that is sort of an incident of people getting together. And so I just want to make sure that we take steps, all the steps that are appropriate to protect virtual assembly and association online as well.
Great. Thank you all very much. Now let's talk a little bit about possible reforms that we can read the political waters right now. There's a real fever to try to do something, anything. What might we do? What types of reforms could we do that might be acceptable, that we could find some compromise on? Is there any reasonable proposals for Section 230?
So I'm going to have one proposal right quick because, I'm not going to be shy about the fact that I think Section 230 got things pretty much right at the outset. I don't think that really changed. That's not fashionable to say, so I have to come up with an amendment to make people think I'm more reasonable about this. And so what is the amendment I came up with? I said, what I would do is add some language to Section 230 that said, this statute is meant to encourage services to make content choices if they think it's helpful to make their services better. And if you just said, basically the purpose of this is not to have a neutral platform, but to empower services to make choices that benefit their users and subscribers, I think that matters a lot, because at least if it's in the statute, they can't be arguing, nobody could be arguing that it's meant, that Section 230 is about neutrality, and it would clear a lot of things up.
Yeah, you have a stacked panel this way. You're only going to get mostly love for Section 230 out of this group. So my reform that I'd like to see is I'd actually like to see us double down on Section 230, make it even more effective, kind of like where Mike was going. I think the solution is actually a federal anti-SLAPP law that would provide a fee shifting mechanism and a procedural fast lane for lawsuits that are designed to suppress socially beneficial speech. But that's not where the politics are today. And the politics are going straight for the heart of Section 230. They're looking for ways to cut it up into pieces that will take away the benefits that we love and that we count on. So when it comes to what could we do to avoid that, there actually aren't many. There's very few ways to tinker with Section 230 that don't start messing with it and all the value it brings.
Yeah, let me just jump in briefly and add to that. The people who are promoting these reforms won't like the reforms if they get them. They haven't, they typically don't realize this. But the people who think they're censored too much will be surprised at how much they're censored if they get rid of Section 230. They're not going to be happy with that. And the people who think, it's just amazing to me that they really haven't thought through the consequences of either having no censorship at all, which makes for toxic online environments, as pretty much everyone here has experienced, and certainly I think women even experience more than men. You have these toxic online environments without any moderation at all. And then the flip side is that if a service does take on the job of policing content, they're going to police a lot more, and you're not going to like how often you are policed.
I think, except for some people who sort of get pushed forward as the poster children for very tragic incidents that get people energized against this, I think that the people who are really behind reforms, I would rather not say people, I would say industries and companies and organizations, the ones who are really behind it are ones who are really adverse to competition, adverse to public speech. And I'm completely unwilling to compromise with them to say, what can we work out? Going to, I think, a question that Michael Nelson raised, I actually don't have a good suggestion for one of the best arguments the other side is putting forward. I could play it, but I could say I have a suggestion for one of the problems I see, which is that speed is a problem, and reach can be a problem, and speed and reach combined with a wrongful message can be a problem. And what is it they say? What's the phrase? A lie gets halfway around the world before truth gets its boots on, or something like that. It seemed to me that, and I'm fantasizing, I'm not proposing it, if people were limited to 10 likes per day, 2 shares per day, you couldn't share anything without adding your own 20 words of commentary, we would slow things down and indulge more thoughtfulness. But we don't limit people to so many pages of paper per month that they can buy. We don't say that you can only have a public expression in a small newspaper, not a big newspaper. We don't limit circulation size of newspapers and letters to the editor and the like. It's not workable under the First Amendment. The question is whether there are market forces that would cause various platforms to differentiate themselves from each other by making their environments more pleasing to their users. What I find fascinating is that we find the biggest criticisms of the platforms that are the most popular. So where do we take that?
If I can just add quickly to Andrew's point, there are services that are experimenting with different ways of slowing down conversations for exactly the reasons that Andrew mentions, that we might improve the quality of the conversation. But those initiatives are being done voluntarily. They're being initiated by the services trying to figure out what their audience needs. And the most important piece to understand is that Section 230 is the legal foundation that enables that experimentation by those services to try the different options without fearing liability for calibrating or miscalibrating the design that they're playing with. So in order to get the kind of outcome that Andrew's advocating for, without legally compelling, which we should not be able to do on the First Amendment, the way we're going to get it is by preserving Section 230. To Mike's point, that's again, it's something the regulators misunderstand. They think that taking away Section 230 might accelerate it. It's actually Section 230 that will accelerate the socially beneficial developments.
Robin, I would just those were all the great points that everyone else made. But I just wanted to also say, I think one of the problems, and this goes back to the question of what's the problem we're trying to solve, is that everyone assumes that if you want to do something related to online content or content moderation, that it has to be within the confines of Section 230. And I think that's flawed thinking. I don't think, for example, if the concerns are about, transparency and accountability to consumers, that putting that in Section 230 would really make any sense. So, part of this is also, once we find the problem that we want to solve, we really should find the best vehicle for it. So I think that's an important part of the policy conversation as well.
Great, thank you very much. Now I'd like to pivot to our attendee questions. We've got quite a few questions and pretty good ones. So let's get started with some of those questions. Okay, our first one is from Ellen Loveledge, and she asks, is there a way to legislatively hold platforms and users more accountable for the extremist content posted online? Who wants to take that one up? Please.
So let me take a shot at that. I have been working on this idea since I published a book in 2019 that really centered on it. And that's that I think we could, beginning at least on a voluntary level, have an industry-wide consensus about ethical treatment of users. I belong to a profession that has a code of ethics that scales pretty well from solo practitioner lawyers to big law firms. The rules about confidentiality and duty of care are essentially the same, no matter what size law firm you're working for. And I like principles that scale, and I think it's relevant in the context of what social media companies and other kinds of platforms have to do. I think that that you have a duty of loyalty, a duty of care, a duty of confidentiality, and some other fiduciary duties. But those are the three main ones. And what does duty of care mean? Well, I think for one thing, it means you don't sell ads to a company that's trying to manipulate people against their self-interest. You don't you don't give advertising space to companies that are trying to manipulate users into doing things that are against their self-interest. And I think companies, that's not an unreasonable thing to ask. And another thing, the duty of loyalty is that if you have users' information, and by the way, the tech companies have lots of information in various ways on different kinds of users, then you have a duty not, you have a duty not yourself to use that information either against your users or to advantage yourself at the expense of your users. So the idea of scraping user information and using it, for marketing or using it to extract more value, without user permission, I think that's something that can be approached from an ethical standards point of view. And the nice thing about this idea is that almost all the ethical codes in the professions were originated first by the professions and then ultimately were backed up with the power of law. So what happens is when you build codes of ethical practice for doctors and lawyers, then suddenly you have a basis for which courts and legislatures can say, oh, well, we know that this is malpractice when a lawyer does it, this is malpractice when a doctor does it, and we're going to create some penalties for that if people act that way. And I think this is a better solution that scales better even than the noble experiment, if you will, of Facebook's oversight board, which, let's face it, is mostly just addressing what Facebook does and not everything that Facebook does. What we really want to do is build a social consensus about what ethical behavior is from the companies. And if we can do that, then I think we would all agree it would be fine to add some law behind that to back up those ethical standards.
Terrific, thank you.
I'm sorry, sorry, Robin, just quickly, I just want to add, I need to note that some things that people would label as extremist content are protected by the First Amendment. So this question actually gets straight to the heart of the discussion we've been having. If you reform Section 230, are you going to run into the First Amendment brick wall? And in particular, with respect to the extremist content, there's already initiatives that are designed to try and address it that Mike might have been alluding to. But we have to ask some questions about whether those efforts, basically an industry-wide block list, creates its own problems with quote censorship or with suppression of things that are otherwise legal content. And that really raises the underlying question, can the government compel an internet service to remove legal content? And I think that's also foreclosed by the First Amendment.
Yeah, I think that's right. But let me just add a little bit to that. As a lawyer, there are things that I could do as a non-lawyer that, under the First Amendment, that as a lawyer I can't do. So because I've taken on more duties in that role than I have as an ordinary citizen. So I'm okay with conditioning certain obligations on the companies as a function of the kind of relationships which are pretty intimate sometimes with users in terms of what speech they allow and what private information they have. But I agree with Eric about the idea that if you have industry blacklists, which I don't favor, that starts looking like something that may raise some First Amendment issues if the blacklist idea is somehow being driven by governmental action.
I'd like to weigh in if I may, because I've seen blacklists in the copyright world being encouraged by the White House, the Intellectual Property Enforcement Coordinator, pulling in payment processors and saying, we think you should stop processing payments for bad people. Not in the copyright world, but I understand that adult performers have a very hard time these days just to get a checking account at a bank because of brand protection on the part of the banks that are facing pressure. And they're saying, no, you're not the kind of customer we want. Now, is that the type of vigilante enforcement that we want? And then you couple it by using terms like extremist speech or hate speech. And something tells me that Donald Trump's definition of hate speech and his definition of extremist speech are going to be very different from my definitions of hate speech and extremist speech. And so how are we going to determine what hate speech needs to be purged, even by industry standards?
Okay, great. Let's pivot to another question here. We've got a question from Eric Berkowitz. How would a repeal of 230 stop moderation? Who'd like to take a stab at that? Please, Andrew.
There'll be nothing to moderate. Look at what happened to Craigslist personals with Fosta Sesta. They're gone. If a company, if the New York Times faces potential liability for any comment that is posted on in response to its articles, it's not sending reporters out to validate every comment. It can't. It's just not going to happen. And anyway, I think that's all I need to say.
Right, so I think, it's important. This is such an important point when it comes to talking about Section 230 and its value. I want to, maybe go back to basics a little bit and break it down. If Section 230 goes away, what we return to is the law that pertains to publishers and distributors, which we heard a lot about in opening remarks. And the important thing to recognize there is that providers face more liability if they try to moderate content than if they just turn a blind eye. And so this is exactly what Section 230 was designed to go after, and to change that dynamic so that providers would be able to moderate. And so, it seems like it would be a really significant loss for companies to lose those types of protections, that by trying to do the right thing, they would become liable for any mistake or any piece of content that might get missed.
I'm sorry, I want to respond to the comment in the chat. The most recent one: repeal Section 230 and platforms will take a more proactive role in moderating or removing content. And I think that this has become a pretty popular meme, especially among regulators, that if we change Section 230, the services will behave in the way that the regulators predict. And I hope that everyone who's viewing this conversation is getting the message that's not going to happen. That the only people who would be in the position to navigate the moderator's dilemma by doubling down and accepting liability for imperfect content moderation are the services that are profitable enough to be able to exist under that model. And it is possible that's a null set. If it isn't a null set, that is only Google and Facebook. And everyone else doesn't try harder, they exit the industry. It has become unprofitable to them. So to think that we can somehow get the rank and file internet service to somehow do more content moderation by increasing the liability that they face is, I think, just misunderstands the market dynamics, and it really is jeopardizing the entire internet industry under that premise.
One of the things that a lot of people have seen, if you've seen these ads online where Facebook is saying, hey, we want to update Section 230 because, it's old, and we want to update anything that's old. But the fact is, Facebook could absorb a high degree of regulation. It's a very wealthy company. Google can also absorb a high degree of regulation, although Google, I think, is a little more far-seeing about some of these issues. But the incumbents, the dominant companies today, can afford to comply with most kinds of regulations that don't add up to absolute bans or absolute prohibitions. They can afford to comply, and they're already rich. They'll figure out the thing that you will have done is not only will you have silenced a lot of individual voices if you incentivize them to engage in more removal of content, but also you will have locked in their market dominance for 100 years. And I don't think that is beneficial even for the companies themselves, but it's certainly not beneficial for consumers and citizens to lock in these monopoly or monopsony providers for a century. I think that's crazy talk.
So one other thing I'd like to talk about in this regard is advertising, because so many of these services that we talk about most are advertising based. I mean, even Facebook, like 98% of its revenue comes from online advertising. And I think it's important to remember, there's been an evolution in online advertising since the old days, back when I worked at Yahoo, and everything was a banner ad, to now we have, promoted, search results or promoted tweets or promoted posts. And most of that activity, which provides a fundamental revenue stream for many, many companies, is what we call self-service, meaning that there is no account manager inside the company working with the advertiser on how, to develop the content of their ad. It is something that users can do very directly. And, this is something that's driven down cost. It's made, this type of advertising really accessible for small business, which is good. But I think we also need to think about, and I don't think we have the answers to this, if Section 230 goes away, what happens to that sort of advertising? Does it just become more expensive? Does it kind of move away? Does it become that, there are just more topics where advertising isn't allowed? And what does that do for, the services that are free to consumers today? Do they stay that way? Or do subscription models need to come in? But also, what does it do to the people who really rely on that advertising for driving, business? I think COVID was a great example of how powerful that can be, because with the constantly changing regulations in different cities, advertising was a really great way to let people know that you were open that day. They could, come in and pick up food, or, that you had to set up outside for restaurants. So I think there's this broader concern also about what the impact would be.
Thank you so much. I think we've got time for one final question. Let's see, we've got a question from Alex Deacon. Given the speed at which innovation happens on the internet, it seems logical that a law set in 1996, the last century, would be due for review and potential update. I'm curious, however, if any of the panelists believe that there does not exist a need to modernize Section 230. Would like to take that one.
I'll go ahead and chime in. Actually, the sponsors of the bill, now Senator Wyden and former Representative Chris Cox, actually expressly addressed this issue. They talked about how when Section 230 was passed in 1996, they contemplated that at the core of their concern was that companies that grew larger were going to have an overwhelming volume of content to moderate. And they could just see how the moderator's dilemma was going to make it impossible for those services to succeed. So with the growth of in larger companies handling a higher degree of scale, their view is that actually Section 230 is working exactly the way it was intended, that there was no need to modernize it. It was designed always to address the fact that the larger the company was, the bigger the problems they'd have, the more that they needed Section 230. So to the questioner, I think you've heard now from the multiple panelists the response, what problem are you trying to solve? Is it simply that it's old? Well, that's not really a problem. Let's talk about what's actually happened in the field that needs to be fixed. And the basic structure of Section 230 was designed to grow with the internet. And in fact, I think it's been spectacularly successful at that.
Yeah, you know, I think the First Amendment's pretty old. So, you know, I mean, really, it's older than me, and we know that I'm pretty old. I established that earlier. So obviously, the First Amendment, you know, as soon as you come up with the First Amendment amendments that reflect how important it is to update the First Amendment, I think I can fit that into my understanding of how to update Section 230.
So I agree with all of those comments. I'm laughing at the chat. So, but I was going to say, you know, this again goes back to what problem are we trying to solve? You know, if someone can bring me a problem that's really important to solve and convince me that changing Section 230 in some way is the way to do that, then fine. I have not heard that yet. And, you know, right now, I think, you know, it's clear that Section 230 has a lot of benefits and that proposals to change it don't seem particularly well targeted to actually accomplish what people say they want them to accomplish. So, you know, I do think that right now, yes, I would say it does not need to be updated. But I think that as we talk about Section 230 and updates, you know, a good comparison for laws that need to be updated might be the Electronic Communications Privacy Act. And I think if you look at that law from the mid-'80s, talking about you know, the remote computing services and electronic communications services and their obligations with regard to communications privacy and responding to law enforcement. You know, when you look at Section 230 next to ECPA, Section 230 is pretty elegant and it's technology neutral. And I think, you know, it really has stood the test of time in a way a lot of other laws that are designed to address technology really haven't.
Great, thank you so much. Now let's move to our final remarks, brief remarks, about 2 minutes each from each speaker. And we'll go in the same order that we began with. So Professor Goldman, you are up.
Yeah, thank you. And thanks for all the great discussion. It's really been fun to have this conversation. In general, technologists are pretty skeptical about the way that laws are made and the competence of regulators to properly regulate technology. And as Elizabeth mentioned, there's a long line of statutes that have been miscalibrated, which I don't think Section 230 has. But more than anything, what we've seen in the last couple of years is that regulators have simply given up caring what kind of collateral damage they may cause to the internet and to the technologies that underlie it. There was a lot of deference in the first 2 decades of the internet. Regulators were tread a little bit more gently, thinking, you know, this is a really important technology. If we get it wrong, that could have really big ripple effects. And the regulators have just stopped caring about that. They've unleashed all their pent-up sensorial energy to try and think, how can we burn it down? And so we're in a really weird place now where we in the technology community should be as skeptical as always of regulators, because we know what happens when they get things wrong. And we have evidence that at this point, they've stopped caring about the collateral mistakes that they might make. So if this is a call to action to everyone who's watching this, that if you care about the internet that you currently enjoy today, that you find is actually solving problems in your life, it is the time to tell your members of Congress that you want them to fight for that and not try and burn it down, because they're probably working to burn it down right now.
Thank you, Eric. Elizabeth, would you like to go?
Sure. It's been a great conversation. I am so glad I got to join. And, I think that, Eric summed it up really well. I think that it's really important, not just that lawmakers and policymakers understand the impacts that Section 230 has for the business community, but also for consumers. And, I think that, it's really incumbent on those of us who understand Section 230 well, and know the value it brings to explain that to a broader audience, so they can understand why maybe they should pick up the phone or write the email, like Eric is suggesting, because this is something that really touches so many different parts of our lives because we do so much of it online. And I would just say there are entire business models that without the protections of Section 230 really would never have existed. And I think, we want to see that type of innovation going forward.
Thank you very much, Elizabeth. Andrew, you have the floor.
Thank you. First of all, thank you.
You're muted.
Yes, I blew it. First time it's ever happened, trust me. First, I want to thank everybody and thank the Internet Society and thank my co-panelists for this. It's been an honor to share the event with all of you. I want to go back a little bit to motivations and to asking people to be careful about the real motivations of the people who are behind this, and also to be careful about some of the particulars that are used as examples, because many of them involve heartbreaking stories. Those heartbreaking stories are absolutely heartbreaking, but I don't think that they are relevant to what needs to happen with social media. So there has been a series of lawsuits against Twitter to force Twitter to pay millions of dollars because of a terrorist murder. And if one stops and thinks, well, should Twitter pay millions of dollars anytime one of these happens? What about all the other parties that would be far more complicit in that, starting with governments, with gun makers or what have you? What is happening is there are a number of cases that seem to promote damages liability for media platforms. And is it really about just making them pay money for all of this? I don't think so. I think it's about saying, well, they must ensure that bad conduct never happens. And that's a standard that we don't apply to, as we say, the bookstores. We don't make it apply to car companies to ensure that a drunk doesn't get behind the wheel. And so in the debate, please stop and think when you hear the horrific stories that will get trotted out, and understand that what's really at stake is the desire to create a legal regime that has no possible outcome other than severely limiting the access of the public to a platform to communicate with the public. That's what's at stake.
Yeah, Andrew just reminded me about the television show 24, which I confess I watched every season of. And if you watch 24, there's always a nuclear weapon or a biological weapon getting ready to go off. And of course, in those cases, torture is okay, because, we'll just forget about compelled self-incrimination or cruel and unusual punishment. We'll just violate the rules, in order, because this emergency situation has arisen. Well, I think the fact is, whenever we approach an issue that way, it's what we do is we excuse ourselves from making ethical lapses. We say, well, the situation was so extreme that our ethical principles ought not to apply, or that our constitutional principles ought not to apply. And I think the thing that's still disturbing, because socially we're still absorbing it, is that these media empower a lot of individuals to engage in a lot of speech and expression, sometimes not pleasant. But generally, you know, the problem with freedom of expression and democracy is that it is a bumpy ride. If it were not a bumpy ride, you would not need a First Amendment to protect it, because everybody would just agree that it was okay for people to say whatever they were saying. And I think that now that we are on the brink of a world in which ordinary citizens can play a very active and engaged role in solving the world's problems collaboratively and collectively, we ought to celebrate that. And Section 230, of course, is not a universal law. It's not a law in every country. But the fact that we're demonstrating that it is possible to create some breathing space for individuals to speak freely on the platforms provided by others, that's so exciting. And we haven't even begun yet to tap the potential for human progress in that development.
Great. Thank you so much, Mike. With that, we will bring this webinar to a conclusion. And I'd like to thank the panelists for their time and expertise, and really interesting discussion, and also thank our attendees for joining. I'd also like to encourage you to come back next month for our next webinar. It's April 5th, same time, same station, 3 p.m. Pacific time. We will have a talk with Dr. Laura DeNardis. The topic is the Internet in Everything, Freedom and Security in a World with No Off Switch. Dr. DeNardis is a globally recognized Internet governance scholar. She's a professor and interim dean of the School of Communication at American University. She's authored 7 books, including The Internet of Everything, which was listed in the Financial Times Best Technology Books of 2020. When the internet is embedded in everything, everything becomes a potential object of surveillance and control. So Dr. DeNardis will talk to us about why we need a new politics of privacy and security. And you can see the link there on the slide for where you can go to RSVP and register for that webinar next month. So again, thank you all for attending, and I hope you will consider joining the San Francisco Bay Area chapter of the Internet Society. You can see the link there on your screen for doing that. And with that, I will bring this webinar to a conclusion. Thank you all very much.